Three, two, one.
This Honorable Court of Appeals of Tennessee is now in session.
Good morning and welcome to the Court of Appeals. Want to take just a few moments before we get started to thank the parties for agreeing to participate in this Zoom video oral argument. It's not the way we would like to be doing things, but obviously it's the way that things must be done to keep the wheels of justice turning. So that's what we're trying to do, and we appreciate you participating in it. This will be an oral argument just as any other oral argument in the Court of Appeals, and the same rules and procedures will apply. Each side will get 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, obviously you've already done that with Mr. Hibner, and you'll receive that rebuttal time. But we'll do things just as if you were in the courtroom. Before we get started, I want to introduce your panel for this morning. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah. I'm Steve Stafford from Dyersburg. We also want to thank Mr. Hibner and his staff, as well as the AOC technology staff, for working so hard to put all this together. They continue to do an excellent job every time we do this. Mr. Hibner, anything else before we call the case?
No, Your Honor.
All right, you may call the case.
Garrett Ramos versus the Electric Employees Civil Service and Pension Board of the Metropolitan Government of Nashville and Davidson County.
All right, we will hear from the appellant.
Good morning, Your Honors. Michelle Owens of the Nashville Bar. I represent Garrett Ramos, and I am happy to be here before you today, even though it's under unusual circumstances. I'd like to first start with a few basic facts. I know that you all have read the briefs and this has been fairly extensive, but basically this is about a lineman, Garrett Ramos, who came onto work at NES from outside. He was an outside hire, and he began work at a grade 11, step 8. That was his pay scale under the civil service rules. This is a civil service situation where pay scales are determined ahead of time with a little bit of leeway based on a little bit of subjectivity and a lot of testing and history and work experience. So when Mr. Ramos first began was in November of 2016, November 21st, 2016. And after he was working for, a few weeks, he happened to work with the head of the union, Mr. Charles Hall. And Charles Hall had known that linemen were being brought in at a lower rate than what he thought they should have been. So he asked him what his pay grade was. And when he learned what it was, he determined that based on his experience, that was very low. And so he brought this up he talked with several people in the union and then brought it up to Jeff Eck, who is the comp and benefits manager, and to Herb DeBerry, who is the vice president of human resources. Other people were also involved, but those were the decision makers. The decision, basically, to make a long story short, was that there was a mistake made, and that all of Mr. Ramos's experience was not taken into account. And this is clearly documented in the transcript, that there was definitely a mistake made, that his years of experience were not taken into account, that his DOL, Department of Labor certificate that establishes him as a journeyman lineman was not taken into account. And therefore, he should have a 2-step increase. And that's what was done. He was given a 2-step increase by Jeff Eck, who was given the go-ahead by Herb DeBerry, the vice president of human resources. And he got this increase and kept it. He got it in December of 2016, so it was relatively quickly. He kept it until July of 2017, when all of a sudden he receives a letter that says your pay was incorrectly increased, a mistake was made, and we're going to reduce it back down. No explanation as to why. And that might not have been so strange, except for the number of meetings and the amount of work and explanation that went into giving the raise. So all of this work and explanation goes into saying why they're giving him the raise. And then all of a sudden in July, he gets a letter that says, sorry, we were wrong. It was a mistake. And during the hearing, it comes out that the mistake was that Mr. Eck did not have the authority to give this raise because he did not go through the proper channels and sign the correct piece of paper that he should have signed. The union believes that this was done because there were other linemen that were also filing this grievance. So NES was looking at other people they were going to have to pay and raise their rates. So the easiest thing to do was just to say we made a mistake with Garrett Ramos and we'll bring his amount back down. So that's what they did. After much appeal, the decision was made that it was a subjective decision that NES was allowed to make. But more than that, it was that NES, that a mistake was made by Jeff Eck, that Jeff Eck did not complete the proper paperwork. However, during the hearing, it was stated by Jeff Eck that he could have corrected this. This could have been corrected very easily by just signing the correct paperwork. However, they did not do that, and they took away Mr. Ramos's pay advance. Now, one thing that's important to note is that Mr. Ramos was started at a step 8. Everyone is brought in at a grade 11. I believe it's a grade 11. And the new hires are at either a step 8, 9, or 10. Okay, so everyone's at a grade 11, but a step 8, 9, or 10. Well, they brought in Mr. Ramos at the lowest step possible, which is a grade 8, a step 8. And considering his experience, it's just really a no-brainer that he should not have been brought in at the lowest possible amount that he could be paid. He should have been brought in at a higher rate.
Ms. Owens, let me ask you, you are aware that in addition to considering his experience, they also did a live skills assessment. And it was on the basis of that live skills assessment that they made a determination about where he should start in terms of his step. You are aware of that, right?
I am aware they did a life skills assessment, but I am also aware that after that life skills assessment, that Mr. Eck and several other people said there was a mistake, that we just didn't consider his past experience. So the skills assessment was passed. He did well in the skills assessment. There was no negative or anything brought up that, would make him not eligible for that. I mean, he's a journeyman lineman with the Department of Labor, which means he can work anywhere with that certificate. So he is well qualified, and there was nothing negative ever said about that skills test. But yes, I am aware of that.
And let me also ask you, you said that Mr. X said he could have just completed a form and that would have corrected it. But that form also had to be approved by others, isn't that correct?
It had to be approved by Herb DeBerry. Herb DeBerry is the Vice President of Human Resources, and Herb DeBerry had originally stated that Jeff Eck could do whatever he wanted, that it was up to Jeff Eck, his call.
Now, as I understand it from the Appellee's brief, in order to get the pay increase, it has to be approved by the manager for that particular employee, and also has to be signed off by the CEO. Is that not correct?
That is correct, but it's more of a technicality. Now, Brandon Whitlock, I believe, was the manager at the time, and the CEO signing off is really a mere technicality, because the Herb DeBerry, actually it's Jeff Eck who makes these decisions, and the manager. Herb DeBerry is the one who really signs off on it, and then kind of takes it to DeCosta Jenkins, the CEO, to say, okay, this is what we've done, sign it off. And, it might even have to go before the board which wasn't brought up, but most things like this do go before the board, and they're just kind of a sign off, just kind of a check the box.
But that didn't happen in this case when he received the two-step increase. Is that right?
And no, it did not happen. Well, it did not happen, but it could have happened very easily. It was kind of an oversight. We have testimony from Herb DeBerry saying that, you know, yeah, this could have been corrected, and from Jeff X saying, yeah, this could have been corrected very easily. It was an easy way out for NES.
Do you have testimony from the manager or the CEO saying that they would have signed off if the form had been submitted to them?
We do not have testimony from the CEO, and I honestly do not know if we have testimony from the manager, because I do not, in what we went through, I don't think the manager is as important as the vice president of human resources, who did say that it was Jeff X's decision, and Jeff X said that a mistake had been made. They brought Ramos in at the lowest possible level, which made the fact there were interns and apprentices who had higher pay than him. He's a journeyman lineman. He was brought in, and because there's some overlap, because of the way the civil service scale works, there was some overlap, and there were apprentices who had not even completed their training who were making more than Garrett Ramos. So that's just incorrect. And everyone saw that at the time, and they changed it, and they left it that way until July, from December until July. And then the interesting thing is that in July is when other grievances were filed. So that seems to be the catalyst for all of the sudden, oh no, there was a mistake made. Let's see what we can do to change this. Because understandably, NES does not want to have to increase the pay of every single one of its linemen, but that's what they were looking at doing. Do you have any other questions? I like questions better.
And your good. And your statement about he was being paid the same as an apprentice, is that in the record?
It is, absolutely. And it's actually in a pay scale that's in the it's in the Civil Service and Pension Board, the original transcript, and it's number 11, I believe. Sorry, number 10 is the pay scale. And you can see the overlap in that. And I would have to look up what it is on the, you know, how on the record, I'm not quite sure. It's in my brief though.
Okay, all right.
At
Yes.
the time that Mr. Ramos was hired, did he know what his pay scale was going to be before he accepted the employment?
He did, and there has been much discussion about that, but Mr. Ramos was an outside hire and had no access to the civil service rules, which would have provided him the appropriate pay scales. So he did not have the access to know what other people were making, like someone from inside NES would have. In fact, you're not able to access that. It's through the intranet with NES, and you aren't able to access it until you are actually hired. So he knew what his rate was. He didn't know what everybody else's rate was, which normally would not be important in a job, but it is in a civil service position where the pay is supposed to be equal. We are not paying people different amounts just because, you know, we like one person more. It's supposed to be relatively similar.
Thank you.
Sure. Any more questions? I think I'm about out of time. I don't know where my clock went.
You are out of time.
Okay, great. At the end.
Just ran out of time. You've got your rebuttal time, and we'll now hear from the appellee.
Good morning. May it please the court, Bob Horton from Bass, Berry and Sims on behalf of the respondent, Nashville Electric Service. Let me quickly say that I appreciate the opportunity to appear by Zoom and appreciate the court's flexibility with the process. Ultimately, the issue here is whether, as the court well knows, whether there is substantial material evidence to support the decision by the ALJ, by the board, and by the chancellor below that the rate was appropriately set and that the changing of the rate was inappropriate. And there is substantial evidence to support both of those conclusions. Let me quickly address 2 points raised by Ms. Owens. with respect to whether there is evidence that there was an apprentice being paid more than the petitioner, what you see in the pay scales is that it is theoretically possible. Apprentices are started at grade 9. There are 15 steps in grade 9. Fully related linemen or linemen with DOL certificates are in grade 11. They also have 15 steps. And if you take the lowest step of grade 11 and the highest step of grade 9, there's a possibility of overlap, but there's no record evidence that an apprentice was being paid more, certainly not at a starting rate higher than the petitioner. Also, Mr. Whitlock absolutely did not testify that he would have approved the pay raise had it been run by him. And in fact, the record evidence is that it was Mr. Whitlock who raised the issue initially. In fact, the evidence is that as soon as he got the automated indication that the petitioner had been given a raise, he immediately went to Mr. Eck and said, "What's going on here? That's not appropriate. It's not what was initially said." Mr. Whitlock testified he participated in the initial process to determine what the petitioner's starting rate ought to be. He testified that the assessment was done as is widely acknowledged as the process, that the committee for the assessment met with HR. There was an agreement that it should be step 8, and Mr. Whitlock's testimony was that it was appropriately set at step 8. To suggest that Mr. Whitlock would have signed off or that Mr. Whitlock's sign off as a mere formality is simply incorrect and not supported by the record. In fact, the record is for an increase to take place, Mr. Whitlock, the manager, has to sign off. Frank Travis, the head of that department, has to sign off, as well as Mr. Eck and the CEO. To suggest that the record evidence is everyone acknowledged it was simply a paperwork error or clerical error is simply not correct. Again, Mr. Eck testified that he didn't participate in the initial process of setting the rate of pay. And I understand the frustration of the petitioner. I understand that the argument that, well, because Mr. Eck said that it should be increased, that's some evidence that it wasn't appropriately set at the beginning. But as the court knows, the standard here is there substantial and material evidence to support the decision of the board? And the chancellor below, and there absolutely is, based on the testimony of Mr. Whitlock. The substantial material evidence standard simply requires that there be a reasonably sound basis for the decision made below, even if the evidence could support a different result, as long as there's sufficient evidence to support the decision by the board and the chancellor, then it should be upheld. And I would submit that that's certainly the case here. In fact, petitioner, other than arguing that because Mr. Eck granted the increase, that indicates that there was some error, there's no record evidence that the petitioner's experience calls for something other than step 8. In fact, the civil service rules indicate that starting rates are set based on competitive practices, as well as an assessment of the petitioner and the assessment of the interviewee. And so not only is it experience, not only is it an assessment, but it's the market, it's the competitive practices. And again, Mr. Ramos, the petitioner, has simply not pointed to, because there is no record evidence saying his experience requires a certain rate of pay. And there's certainly substantial evidence to support the decision with respect to setting the rate of pay. There's also substantial and material evidence supporting the determination, again, by the ALJ, by the board, and by the chancellor, that the increase was inappropriately given. Again, I understand the frustration of the petitioner and the argument that, well, if the head of HR and the director of comp and benefits approved the increase, they must have the authority, and so it must have been okay for them to do that. But the record evidence is that the process, procedure, and policy at NES is that such a raise can only be given if the manager, as well as the head of the department, along with Mr. Eck, and then the CEO, all sign off on that decision. That is the record evidence. There is clearly substantial material evidence to support the conclusion that the raise was given to Mr. Ramos inappropriately. And again, there is absolutely no record evidence that this was simply a clerical error that could have been fixed by filling out a piece of paper. Again, it was Mr. Whitlock, the manager, who immediately raised the issue and asked why the raise had been given and said he believed it had been given inappropriately. I know that I wanted to address in my time the due process issue as well. I noticed that it was raised again. It wasn't raised below with the chancellor, but has been raised in the petitioner's brief and the reply. And so I wanted to go ahead and address that issue. Petitioner argues that, first of all, that argument cannot be waived. The case law is clear that it can be waived. Of course, we cited in our brief to the Powell versus Community Health System case and the Banks versus University of Tennessee case, indicating that it's axiomatic, the court said, that parties cannot raise issues on appeal that they did not raise in the trial court. Mr. Ramos cites to a case out of Hawaii that was dealing with a plea agreement, and the court addressed whether or not, based on plain error, the court could address that without it having been raised below. And that court noted, number one, that other states have set different standards in terms of whether or not that would be the case. But there's certainly no Tennessee case indicating that an argument about due process and property rights with respect to a raise cannot be waived. And in fact, a case cited by a petitioner in this briefing in this case, the Tennessee Supreme Court case of Bailey versus Blount County Board of Education, addressed that very issue. It was an assistant at a high school who raised a termination issue. And the court looked at whether he had waived his due process arguments. And the court said, you absolutely can waive those due process arguments, and that he did. I would also point out that as the administrative law judge held, and we pointed out in our brief, even if the due process issue had not been waived, the petitioner has not demonstrated that he has an entitlement to a certain salary that would give him a due process right, a property right that gives him due process rights. The petitioner seems to argue that because under this Metro charter that an employee can only be discharged, suspended, or otherwise punished for just cause, that means he also has a due process right with respect to his salary. That's simply incorrect. In fact, the Metro charter also says that the NES board has the right to fix the salaries for compensation within the limits of the pay plan, and clearly that was done here. Within the limits of the pay plan, Mr. Ramos' initial wage was set. The closest case in Tennessee that I've found is the case also cited by the ALJ in terms of whether there's a property interest. And it's the Green versus City of Memphis case, in which the Court of Appeals looked at an issue in which police officers who were hired in accordance with the Memphis City ordinance that said they could only be suspended or demoted for just cause. In that case, the police officers had been given a promotion, and then the promotion process was found to be unlawful. And so those promotions were removed. And the issue in that case was, did they have a property right in those promotions? And the court said, no, that they don't. That because of the Memphis ordinance granting them a just cause requirement for suspension or termination, they had a property right with respect to those issues. But with respect to the promotion, the court held they do not have a property right with respect to those promotion issues. The case cited by the petitioner asserting that he does have a property right, the American Federation of State versus City of Memphis case does not support the position of petitioner that he had a property right interest either. In that case, the City of Memphis had passed an impasse ordinance. In Tennessee, the municipality, according to the Court of Appeals, can only enter into collective bargaining if there's a municipal ordinance or state statute granting that municipality the right to engage in collective bargaining. And in that case, the Memphis City Council had passed an ordinance called the Impasse Ordinance that gave the city the right to engage in collective bargaining, really said arbitration. in certain circumstances. And so the court held in that case, there may be a property interest in a memorandum of understanding negotiated as a result of that ordinance in Memphis. And ultimately, a year later, the court said, I don't actually have to find whether there's a property interest here or not, because I believe the due process had in fact been granted. So in that case, the court did not hold that there was a property interest in the wages. And that case is obviously very specific to the ordinance passed by the city of Memphis that granted the opportunity to engage in collective bargaining. So it has no relevance here. And finally, I would point out that even if Mr. Ramos was entitled to due process, he got it. I mean, not only was he heard initially in terms of whether or not he had been given a proper starting wage, but he filed a grievance. He went through a 4-step process. The record evidence is even at that 4th-step meeting, the petitioner testified about his meeting with the CEO, that he was given an opportunity to be heard. Then he had a hearing before the administrative law judge, which was a full evidentiary hearing. The Tennessee Court of Appeals in Case versus Shelby County Civil Service Merit Board says that even in a termination case, you would look at the issue is, was the individual given a right to be heard? And you would also combine both pre and post termination hearings to see if due process was granted. I would argue, Your Honor, that even if he was entitled to due process, the petitioner was heard multiple times in multiple forms and given the opportunity to present every bit of evidence that he possibly could want to throughout the course of this process. So again, may it please the court, there is substantial and material evidence that clearly supports a decision by the ALJ, the board, and the chancellor in this case, that the petitioner's initial wage rate was properly set and that the process and the procedure was flawed and in violation of the company rules when he was given the raise by Mr. Eck, who did not have the authority to do so without the sign off of Mr. Whitlock, Mr. Travis, and the CEO. Thank you, Your Honor.
Thank you. Ms. Owen, we'll hear from you in rebuttal, please.
Thank you. And I want to point out that I did not review the standard of review because I believe that this court knows the standard of review. But I did want to point out that the substantial and material evidence aspect of this standard has not been met whenever by the respondent. When you look at document 4 in the record, page 272 through 273 and 4, it specifically states that information was given. It says, Charlie gave me information about his years of experience, meaning Mr. Ramos's, and it was different than what was on his resume and when he was hired. He also says that he talked to Pam, and I can't remember her last name right now, but she was one of the one of the decision makers as well. And they said, what do we do? Well, we give him a 2-step increase. So they gave him the 2-step increase. And that is in the record. When you look at Civil Service Rule 4.012, it says the starting rate for a new employee will be based on the employee's qualifications, including previous work experience and competitive practices. According to his previous work experience, it's very clear in the transcript in document 4 of the index that all of his work experience was not considered. So that is substantial and material evidence right there that he was given the incorrect starting pay rate. As far as the due process argument, the fact that this is being treated as a state agency, which sometimes NES is this quasi state agency, but it is a state agency which gives Mr. Ramos a property right in his pay. And you can't just take it away without some due process. And that is a very long-standing legal premise And I think that's all I have. If you have any questions, I have 35 seconds.
I don't see any questions. Thank you for your argument. Thank both of you for your arguments, and we will attempt to get you an opinion resolving this issue, at least at this level, as quickly as possible. Again, I want to thank Mr. Hibner and his staff and the AOC staff. Mr. Hibner, if you will recess the court until the call of the next case, please.
This honorable court is now in recess until 11 a.m.
Thank you.
Your honors.
Thank you.